When we talk about shares in a company, think about it as having a piece of a larger cake. This is day 6 of the 30 days Know Your CAMA challenge, and we're pressing in. We're locked in. Today, we're looking at sections 124 to 148. Share capital. Let's go. There's a minimum issued share capital for every company, like we talked about. I think it was on day 2. And of course, for private companies, it shouldn't be less than 100,000. And for public companies, it shouldn't be less than 2 million. However, if you're incorporating a company in an industry, or would I say a sector now that has its own prescribed minimum issued share capital, then you should take note of that. But no company shall be registered with less than the issued minimum share capital. We move on to the next, which is increase of issued share capital and notice of such increase, which is most common. And this is in sections 127. It says that a company having a share capital may increase its share capital by allotment of new shares of such amount as it considers expedient. However, this increase must be done in a general meeting or by the resolution of board of directors. Where a company increases its share capital, it shall within 15 days after the passing of that resolution notify the CAC, that's the commission, of such increase. Sections 127 sub 3, however, makes provisions for where a company ought to where a company requires approval by virtue of another act or regulator. All of the procedures that is associated with that approval is outlined subsections 3, subsections 4, and subsections 5. Because of time, we won't be going into some of these details. We go on to sections 128 that talks about increase of issued share capital, and it simply provides that where a company allots new shares by increasing its share capital, at least 25% of the issued share capital shall be paid up, right? And the directors shall also deliver a statutory declaration verifying that particular fact. And of course, you know that anytime the commission gives a direction for something, if it is not done, there's a penalty. Sections 128 sub 2 speaks to that penalty. We've looked at increase in share capital. What about reduction in share capital? Sections 138 strictly says that except as authorized by this act, a company having a share capital shall not reduce its share capital. So where the issue of reduction of share capital comes up, there are requirements outlined in CAMA. You should look at sections 131, or I think down to almost 134 or 135. Yeah, 135 as to regards to reduction of share capital. So we move on to sections 137, talking about miscellaneous matters relating to share capital. So it is the duty of directors in a public company that where the net assets of a public company is less than half of its called up share capital, the director shall not later than 30 days from the earliest day of which that fact was known to them convene an extraordinary general meeting for a day not later than 60 days from that day, for the purpose of considering whether any, or if so, what steps should be taken to deal with the situation. Move on to the rights and liabilities of share capital, and the rights and liabilities of shares in sections 138. And it just simply says that subject to the provisions of this act, the rights and liabilities attaching to every share of the company or any class thereof shall be dependent on the terms of the issue of these shares or the provisions of the company's articles. And then, notwithstanding anything contrary to the terms or the articles, this right shall include the right to attend the general meeting and vote at such meetings. Shares are transferable property as stated in sections 139. So they are like your property. You can do with them as you please. However, subject to the articles of association. We go on to see sections 140 that prohibits non-voting and weighted shares. What that means is that every share that a shareholder holds entitles him to the right to vote. And Any provisions as to the article or anything contrary that takes away that right is prohibited, it's invalid, it's not backed by CAMA. We move on to issues of shares. Powers of company to issue shares. Company can actually issue its share. However, let's look at the preemptive right in 142. It says that a private company shall not in any event allot newly issued shares unless they are offered in the first instance to all existing shareholders of the class being issued in proportion as nearly as may be to their existing holdings. So what that means is that you cannot issue newly allotted shares to just anybody except you've offered them first to the existing shareholders. The details of how you should allot that is contained in 140 sections 142 sub 2 and 3. We move on to issues of issue of classes of shares. A company may, where so authorized by its articles, issue classes of shares. And I think we're going to look at classes of shares as we proceed in looking at CAMA. We now look at issues of shares at a premium. Shares can actually be offered at a premium. That's sections 145. And section 145 goes ahead to provide that there shall be a share premium account where this like I forgot to add that this premium can actually be offered whether for cash or otherwise, right? And the aggregate amount or value of the premium on those shares shall be transferred to this share premium account. We move on to you see we've talked about issuing shares at a premium. However, sections 146 says that you cannot issue shares at a discount. It is simply on, in fact, it's like in the Bible that we have the shortest verse that says Jesus wept. This is like 146 just says it is unlawful for a company to issue shares at a discount. Full stop. So it's unlawful, right? I think we move on to the next, which is the last for today. 148 talks about the validation of improperly issued shares. So it just simply says that where a company has purported to issue or allot shares, and the issue or allotment of those shares are invalid by reason of any provision of this act or by or other enactment of the articles or terms of issue or allotment were inconsistent with or unauthorized by any such provision, the company may, within 30 days of an application by that holder, a mortgagee of those shares, or by a creditor, and by a special resolution, validate the issue or allotment of those shares or confirm the terms of the issue and allotment as the case may be. And where the company refuses, there's a remedy. These persons may approach the court, and the court may, by upon application, actually validate those shares. And in every case where the court validates an issue, allotment of shares, or confirms the terms of an issue or allotment in accordance with subsection 1, it shall make upon the payment of the prescribed fees an order which is proof of the validation or confirmation, and upon the issue of the order, those shares are deemed to have been issued or allotted upon the relevant terms of issue or allotment. I think that's all we can take in day 6 of this 30 days journey. I'll see you on day 7.